So what we ask of jurors when they're impaneled is to be the judges of the facts. They judge the facts. The judge doesn't. The judge's opinion as to whether that person is guilty or not guilty has no relevance, has no power, no authority. And so we ask the jurors to make the decision. The judge is the judge of the law and the judge of the rules of court. I'm going to follow. So, I really do want to note, there are different systems around. So if you go to France, there's not a similar, they're more inquisitorial than adversarial, and their justice system doesn't work with juries much. I believe they have a bit. If you go to Japan, they've got a different model where 5 or 6, I can't remember the number, of people sit with the judge, and the judge is part of it. There's some people who advocate for expert panels. You know, so if I'm charged with fraud, the jury will be made up of forensic accountants or something like that. I'm not a big fan. Well, I don't mind any of those, but I think I tend to come back to the system we have. Any thoughts, questions? Yeah. Look, the question was around that balloting off the extra jurors at the end of the trial and whether you can make 3 of the votes redundant, you know, so 15 go in. It's a great question, and I think it warrants hours of study. My gut is that it's not really a vote so much in the deliberation room when there's 12, although some may choose to vote, you know, go around and say, what do you think? But the law says that the jury, no matter how many are on it, 12, 11, or 10, have to reach a unanimous verdict, right? So the prosecution has to convince every one of them, not most of them, or not the majority. Now, I'm going to say something here that I don't want to confuse the matter. A judge can order a majority verdict. If the jury has been deliberating for a while and they can't come to the decision, a judge can, doesn't often happen, say, I tell you what, I'll take 11-1. But not majority 7-5, 11-1 or nothing. You can't reach a verdict. And the judges occasionally do that. But it's not really like it's not like an election where, you know, if you get more than 50%, really the burden of proof is without beyond reasonable doubt. The only other thing I want to say, and this is the only way to say something serious is to joke about it. At least that's what I think. My children think don't agree with me, but I'll try this audience and see what you think. One of the emerging issues in jury management and jury trials is the use of technology and the internet. Now, I know every one of you has got a phone in your pocket. I know probably half of you are looking at it right now. The days of a judge, see, you know, 10 years ago, 15 years ago, a judge would say to the jury, I direct you not to do any of this stuff. It's in the Act. You're not allowed to do your own investigations. You're not allowed to do your own experiments. If I was charged with, I don't know, mixing, you know, making amphetamines or something, and I had chemicals, you're not allowed to go start mixing them up, seeing if it works, you know? You're not allowed to go to the scene where I allegedly did the crime. You're not allowed to look on the internet. If you don't know what beyond reasonable doubt means in your own head, you ask the judge, but you can't go and Google it. Now, we're struggling with this because I can guarantee you right now, if I said, I'll make it up. If I said Carleton won the grand final in 1974, in 10 seconds there would be a scream that said, no, they did. If I said, I know the answer to this one. If I said Carleton won the grand final in 1993, within 10 seconds there would be a scream out saying, no, you're wrong, it was Essendon. Because all of you would have gone to your little phones and found the answer. Well, you can't do that when you're on the jury. In fact, you're in breach of the Act, and if you do it, you find yourself in the magistrate's court facing a pretty big fine. But people do it. So when you're finished all this, I will allow you to Google dumb things jurors have done. And you will come up with the funny, you can't make this stuff up, okay? So there's a woman, Frail, I think her last name is, in the UK, who's doing, she's probably out now, 8 months prison because she thought it was a really good idea sitting in the jury box to friend the accused, the guy who's charged, on Facebook, and have an ongoing relationship with him on Facebook. And look, there's a whole bunch, and I won't waste your time with them, but my favorite is the guy in Arkansas, and it was a civil trial. It was a commercial. One person was suing a company. And from the jury box, before the verdict, he tweets, if you've got shares in this company, I suggest you sell them. They're going to be about $80 million short. Their pocket's going to be $80 million lighter very soon. So this kind of stuff drives judges nuts. And we've had a couple of, I tell citizens when they come into the jury pool room, I tell them this, or my staff do, and we say the last thing we want you to do is to be across the street at the Magis Court facing a fine. Now in the last 12 months, last 18 months, we've had 3 people, allegedly. Well, 2 of them proven. 1 dropped. The charges were dropped. So, one of them was, I'll just tell you in general terms, the person at the end of the trial, first day of deliberations, showed up with reams of paper printed off the internet about what post-traumatic stress, definitions of post-traumatic stress and definitions of forgotten memory, when you get those retrieved memories from childhood abuse or something, just mad. And what happens is the judge has to discharge that jury and start all over again.